classrooms available. And now we have just a surplus of classrooms, so I never, thus far, I haven't had to leave the 5th floor. So this is nice to have this space, and it gives us a lot of scheduling flexibility also.
And it's a good, for a larger class, it's a good setup without feeling sort of cavernous.
Yeah. And we've got some larger rooms upstairs. Sit tight.
Okay.
I'm Bob Kaiser, director of the Wallace Stegner Center here at the University of Utah Quinney College of Law, and it's my great pleasure to welcome you not only to the first Stegner Center green bag of the 2015-16 academic year, but also to we're just thrilled. You may actually be able to see the screen. You may be comfortable sitting there, and the food is as good as ever. The Young Scholar Program is now 10 years old. It was founded in 2005, and since its inception by the Cultural Vision Fund. The goal of the Young Scholar Program is to recognize and establish a relationship with promising scholars early in their academic careers. We select recipients annually on the basis of their academic accomplishments and promise. And we have an outstanding young scholar. I think young is still in a boilerly date today with us, and I'll introduce him in a second. Let me note before turning to today's program that there are some upcoming Stegner Center programs that I wanted to make you aware of. Dave Owen will be doing a program downtown tomorrow at noon at Holland and Hart law firm on the evolving law of Headwater streams, cast as a continuing legal education program. On the 22nd of October at the Hinckley Institute, Stegner Center is co-hosting with the Hinckley Institute a program featuring Ritwik Dutta, who's an advocate before the Supreme Court and the state high courts of India on India's environmental challenges and new judicial solutions in that nation. If international environmental issues and law interest you, this should be a program of considerable interest. A couple of other green bag programs for the Stegner Center. On November 17th, we'll have 3 separate speakers here who've all been participants in the Mountain Accord process, and they will be discussing their experience there and that process from their own respective perspectives. And on December 3rd, we'll host Cullen Battle from Fabian and Clendenin, who will speak on recent developments in Utah stream access law. subtitle is Log Drives and Navigability, a critical question in ascertaining public access to streams here in the state of Utah. Now let me introduce Dave Owen, who teaches at the University of California, Hastings College of Law in San Francisco. He teaches courses in environmental, natural resources, water, and administrative law, sort of the full package in the environmental area. He previously taught at the University of Maine School of Law. He joined the Hastings faculty in 2015. He's a graduate of the University of California, Berkeley School of Law, where he served as editor-in-chief of the Ecology Law Quarterly. He was selected for Order of the Coif Honors upon graduation. He also then clerked for a federal district court judge and worked in a small law firm in San Francisco before turning to academia. His legal work in California involved Colorado River allocation decisions, the Sacramento-San Joaquin Delta litigation, and he had some involvement with the Yucca Mountain Nuclear Waste Repository and the issues surrounding that. Most recently, his research is focused, as his talk does, on water resource management. He's taken a look at questions involving dam removals and hydropower upgrades, as well as groundwater use regulation and implementation of the Endangered Species Act. So please join me in welcoming Dave Owen as our young scholar for this year.
Thanks. So to answer your earlier question, when I told my dad about a year ago that I'd been invited to give this talk, he gave me this quizzical look and said, "David, you're not young." So, I am very, very flattered as I am, and I'm going to cling to that as long as I can. I'm also very flattered to be giving a talk at the Stegner Center, particularly the first one in this new building. Wallace Stegner really was the dean of Western water writers, and to have my name in even any form of association with his is really a true honor. So the talk I'm giving today has sort of a simple thesis at its heart. And that thesis is that the recent history of regulation of headwater streams offers both a hopeful and I think an instructive parable on the recent history of environmental law and the future of where environmental law may yet go. And I'll explain that in some detail, but let me start with a little bit of current events. A couple of months ago, the U.S. Army Corps of Engineers and the U.S. Environmental Protection Agency released a new rule defining the scope of federal jurisdiction under the Clean Water Act. In other words, this rule determines which streams and wetlands and other aquatic resources are subject to the Clean Water Act's protections. And EPA and the Corps told the public that this rule really was not going to change very much about existing practices, that the changes in jurisdictional determinations would be pretty subtle. And I think that is entirely correct, but the reactions in a lot of circles have been apoplectic. Lots of other politicians have said very similar things. Lawsuits are now flying left and right, about a dozen in the federal district courts, about another dozen in the federal courts of appeals, political bills designed to repeal the new rule. People are very, very angry about it. And of course, that may sound perfectly routine. A month or two later, the Clean Power Plan came out, and we have more or less the same reaction. So here you see Mitch McConnell telling states to do whatever they can to sabotage the new rule. This just seems like par for the course these days in environmental law. And so it can often seem, and we often say this in both policy and academic circles, that environmental law has devolved into trench warfare, that everything is litigated, that we're making no real progress, and that we're just plain stuck. And it's also increasingly popular to draw sort of nostalgic comparisons to the 1970s, a time in which abundant environmental legislation emerged from Congress, and typically with very high levels of bipartisan support. So for environmental lawyers, at least those who want to see stronger and more effective environmental laws, this can seem like a sort of depressing era. But in the area that I'm going to talk to you about today, The law is not stuck. It has changed, and it has changed recently. It has changed fairly dramatically in the last 15 years. And so what I'm going to do is start out by telling you a little bit about this area of law, the law that governs headwater streams, these sort of obscure watersheds. And then so I'll start by explaining why these are important, why we might care about them. And then I'll talk a little bit about how the law governing them has evolved. And then I'll step back and talk about how I think this offers a somewhat more optimistic window into the recent history and perhaps near future of environmental law. So our story starts here, and these, of course, are not headwater streams. Those are major rivers, Boston Harbor, Lake Erie, and these are the kinds of water bodies that we typically think about when we think about water quality. This is what we write poems and novels and songs about. This is what legislators were probably thinking about when they passed the Clean Water Act. And for a long time, this is where a lot of scientific attention was as well. Streams higher up in the watersheds weren't getting a whole lot of study. But almost all of the water, or at least most of the water in those larger waterways, starts out someplace that looks like this. It starts out in what we might call a headwater stream. And just to introduce some terminology, EPA, nobody really gives a very precise definition of a headwater stream in the literature. Generally, they're the streams that are up there at the top of the watersheds. And I'm not going to try to give you a more precise definition here. And when we talk about headwater streams, we typically are talking about three general categories of streams. There are perennial streams, which pretty much always have flow, intermittent streams, which flow during relatively wet periods when groundwater tables rise up to intersect with the surface, and then ephemeral streams, which are almost always above the groundwater table and which contain flow only during and relatively soon after major storm events. And collectively, these streams make up many of our river and stream miles. Watersheds typically look like this. We have we have main stems, and many, many different tributaries feed into those main stems. And if you add up the miles in the tributaries, they're going to be much greater than the miles in the main stems. Similarly, if you think about what aquatic features are most likely to intersect with people's land ownership, again, it's the headwater streams that reach furthest out into the landscape, and therefore are the features we are most likely to interact with. And these are very, very abundant aquatic resources. This map's a little bit hard to see, but the dark brown areas basically show watersheds in which upwards of 82% of the stream miles are intermittent. Now, not every intermittent stream is a headwater stream, not every headwater stream is intermittent, but still the basic point this conveys is that most of our river and stream miles, in some places like the arid Southwest, very nearly all, are in these upper headwater stream type features. Even in relatively wet areas like the Southeast and the Northeast, most of the stream miles still are headwater streams. They just tend to be perennial. So these are very common features, and that is one reason why they are important, worth paying attention to. They also turn out to be very environmentally important. And I'll give you a couple of examples of reasons why. So this nasty looking stuff is blue-green algae blooming on the shores of Lake Erie. It looks bad, and it is bad. It's highly toxic to people or pets who might may swim in or drink the water. If it blooms in sufficient abundance, it can also suck all the oxygen out of the water column, rendering it unfit for just about anything else to live. And these tend to be very pervasive problems. Algae blooms and the nutrient overloading that causes them occur in many, many of our rivers and lakes and streams and estuaries, and the geographic scale of the problems can be enormous. So if you see here at the bottom of this map, those are algae blooms taking up much of the southwest part of Lake Erie. And those blooms would be dwarfed by the ones that form south of the Mississippi River Delta in the Gulf of Mexico. These happen, it turns out, partly because of what we do with headwater streams. They happen, the most immediate reason why these blooms happen is because waterways are overloaded with nutrients, things like phosphorus and nitrogen that in modest amounts support the entire food chain and in excessive amounts can support these runaway blooms. And those nutrients typically run off landscapes and run through headwater streams along their way to river main stems. So headwater streams are the vectors that transport these nutrients to larger waterways. They also, it turns out, are particularly good at sucking nutrients up. There are lots of bacteria and other creatures that live in the soil beneath these streams and the banks of these streams that are quite good at processing nutrients, taking them out of the water column and avoiding harms further downstream. But when we fill these streams in or channelize them, when we take away their ability to provide that biological function, the downstream water quality problems get much worse. So there's now pretty much a consensus emerging in the scientific literature that if we want to avoid these big algae blooms, we've got to take care of the headwaters. Another set of examples involves biodiversity. So there are a lot of species that live primarily or even exclusively within headwater streams. There are other species like the salamander and the stonefly that you see here that breed in streams and then migrate to surrounding terrestrial landscapes. Then there are a number of species like the trout and the salmon that you see here that breed primarily in headwater streams where the numbers of predators are relatively low and then migrate throughout river systems or even all the way to the ocean. And then there are still other species that might live primarily downstream but use these headwater areas as refuges when temperatures get too high or pollutant levels spike or invasive species take over the main stem. And then if conditions downstream improve, they can then repopulate those downstream areas. So the bottom line is there's also an emerging consensus in the scientific literature that headwater streams are exceedingly important to the biodiversity of entire watersheds. But these streams are also really vulnerable. In urban areas, this is the typical fate of a headwater stream. They are quite often converted to culverts or ditches or buried or otherwise obliterated. And this happens at a really broad scale. So this map shows Portland, Oregon, and the orange streams that you see there no longer exist. They've been simply removed from the map by urban development. And that type of change is very typical across urban landscapes, not just in this country, but all over the world. The streams that stick around often aren't doing a whole lot better. They typically have heightened pollutant loads. They have flashy flow patterns involving both floods and droughts. They're physically altered. And a whole confluence of stressors generally leads to very low water quality and a condition that stream ecologists now just refer to as urban stream syndrome. Streams also these headwater streams tend to do fairly poorly in agricultural regions where they can be converted to cattle wallows or irrigation ditches, removed entirely and converted to tile drain systems that basically take the water out from beneath fields rather than flowing it over the surface, or pumped dry by surface water diversions or groundwater use. And then some of the heaviest impacts of all happen in the southeast in coal mining country, where literally well over 1,000 miles of streams have been simply buried beneath the rubble left over after mountaintop removing mining operations are done taking the tops off mountains and taking the coal. And why do we do this? Well, one reason, again, is that these streams are very abundant. They just have a tendency to get in our way. But another reason is that both as a legal matter and as a cultural matter, and then also as a scientific matter, we simply haven't placed a whole lot of value on these types of streams. We haven't studied them, we haven't focused on them, and we haven't, to a large extent, protected them. And that has made them quite vulnerable to destruction on a very wide scale. So what does the law have to say about this? Well, there are a lot of different laws that in one way or another provide protection, or at least could provide protection for these sorts of small streams. But probably the most important law, the workhorse in this realm, is the Clean Water Act. And more specifically, it's the combination of two Clean Water Act sections, Section 301 and Section 404, that provides much of the protection for these streams. Section 301 prohibits discharges of pollutants into waters of the United States without permits. And one of the permitting programs comes from Section 404, which allows the release of dredged or fill material into waters of the United States. In other words, allows them to be filled if you have a permit. The permits are issued by the U.S. Army Corps of Engineers, which runs the program in partnership with the U.S. Environmental Protection Agency. And in administering the program, the Army Corps follows a basic hierarchy. It's actually kind of inaccurately stated on this slide, but I liked the slide, so I used it anyway. The basic goal is to get people to avoid causing stream impacts at all. To the extent they can't be avoided, the Army Corps asks permit recipients to minimize those impacts. And to the extent they cannot be avoided or minimized, they still must occur, the Army Corps asks for compensatory mitigation. And that generally means asking permit recipients to restore or enhance or create or just protect equivalent aquatic resources someplace else. The Army Corps also uses two basic permit types to implement the program. One type is called a general permit. Typically take a lot longer to write and they cost more time and money to obtain. And then general permits have sort of standardized one size fits all requirements for similarly situated classes of actions. They're less flexible, but that lack of flexibility means they're also much quicker to write and obtain. So those are the basic parameters of the program. But for this research project, I was trying to get at the history of it to figure out how it has been implemented over time. And that's the next part of the talk. And the discussion that follows draws partly on sort of traditional paper documentary research. It also draws fairly heavily on a series of about 50 interviews that I did with Army Corps regulatory staff, with staff at EPA, with people at state environmental agencies and other federal agencies, and then some folks as well in the private sector. And I think we can eras with sort of loose boundaries between them. Starting off with the early years, this is the period from about 1972, when the Clean Water Act was passed in more or less its modern form, until the late 1980s. And fairly early on during this period, the Army Corps began asserting jurisdiction over streams and wetlands fairly broadly. It didn't do so initially. Initially, it had to be forced by litigation to move to a broad definition of its jurisdiction. But by 1975, the Corps was asserting jurisdiction fairly extensively. But it also drew a sharp distinction between waterways that were subject to its jurisdiction and waterways that it would actually protect. And it carved out a fairly huge zone of exemptions for streams, for isolated and small wetlands, and then also for streams with less than 5 cubic feet per second of average flow, which in other words means nearly every stream in the state of Utah. For those streams, there was initially essentially no real permitting required at all, and then under a permit known as Nationwide Permit 26, those streams could generally be filled without even providing advanced notification. And I think this has some interesting implications for the present debates about jurisdiction in the new Clean Water Rule. In a lot of the court cases and a lot of the debates about the current rule, you would get the impression that once EPA or the Army Corps, and everybody says EPA, they don't like to talk about the Army Corps for some reason, once they assert jurisdiction, heavy-handed regulation will inevitably follow. For many years of the program, that was not true at all. The boundaries between what was regulated and where jurisdictional boundaries occurred were fairly, or the disparity between the zone of jurisdiction and the zone of regulation was quite wide. And in the field, this had dramatic effects. This meant that for waterway streams that looked like this, it was essentially a fill-at-will regime. And all the staff I talked to were quite clear that that had meant that huge areas of streams, and wetlands as well, had gotten filled during those years. So why did the Army Corps do this? The answer is partly cultural. The agency had been traditionally staffed almost entirely both of those things, and its orientation had been towards protecting navigation and building stuff, big stuff, environmentally destructive stuff quite often. And so protecting these sorts of small streams and wetlands really did not fit within the agency's traditional orientation or even its competence. But there was another reason as well, and a reason that I think captures a more general problem with environmental law in the 1970s. If the agency really was going to go out and protect lots of small streams and small wetlands, that was going to require exerting regulatory authority over a lot of little decisions that were making just incremental changes in the overall quality of our environment. And the statutes of the 1970s clearly aspired to that level of protection, but we really didn't have the professional infrastructure in place to actually go out and do it. We didn't have the staffing at a lot of federal agencies. We didn't have the experience with these new laws. A lot of regulatory tools that would later evolve hadn't really come about yet. And then on the industry side, industry wasn't used to complying with these requirements, and there wasn't really the same sort of environmental consulting industry that we have now to help industry. So it wasn't just that the Army Corps didn't want to do it. It wasn't really equipped to tackle this sort of problem. Then we move to the next era, which we'll call the no net loss of wetlands era. And this era really could start roughly around the 1988 campaign, when George Bush the Elder pledged that if he were elected president, his policy would be that there would be no net loss of wetlands on a nationwide scale. And in addition to those changes from the top, the Army Corps itself was changing. It had started to hire biologists, and then later on it had started to listen to them. And it also was getting a lot of pressure and education from the other environmental agencies that it routinely worked with. And all of this was leading to a gradual embrace of an environmental regulator's role. The Army Corps and other agencies were also developing new tools to regulate. And one of the most important tools is something known as compensatory mitigation, which basically means restoring or protecting wetlands in one place in exchange for the destruction of those wetlands in another spot. Initially, this was done pretty badly by all accounts. Typically, the trades involved creating wetlands that failed to provide any real function and sometimes failed to even last as wetlands in exchange for the destruction of real and highly functioning wetlands. But it also meant the beginning of a learning process that, based on everything I heard from the people I talked to, has led to improvements in the practice over time. But the changes of this period were focused almost entirely on resources that looked like this. That is, they were focused on wetlands. All of the rhetoric was about wetlands. It was just no net loss of wetlands. The permitting requirements that the Army Corps set forth, again, were tailored specifically to wetlands. Compensatory mitigation during this period was all about wetlands. And vestiges of this still linger. Robin and I were just talking before I started about how if you open almost any environmental law casebook, even today, but not Robin's, the unit on section 404 will be entitled something like, and the word stream may not even appear anywhere in that chapter. And then this happened. In 1994, conservative Republicans stormed into Congress, taking over both chambers. And I think a lot of environmental scholars and policy people view this as really the death knell for the environmental legislative era. Nothing major had been passed at this point since 1990, but this was the point at which it began to seem like nothing was going to be passed, and that the future battles would simply be about possibly retrenching environmental law or perhaps holding the line. There is an exception. We have done significant things in fisheries law since then, but you're in Utah, so that's probably not a big concern. But other than that, environmental law at the statutory level has been remarkably static since that time. And you might expect that this would be where the story ends, that whatever the protections were in place in the early 1990s would have remained relatively fixed or perhaps rolled back a little bit to the present day. But that's not what happened. And instead, now we enter into what I'll call the stream protection era, an era that is really still unfolding today. And there are a couple of indicators we might look to see that change. The one I will start with is permits, and specifically the terms of general permits for stream impacts. So imagine for a moment that you're a developer. You're a developer who builds things that look like this, only perhaps much, much bigger. And when you build things that look like that, you often impact streams, sometimes ephemeral, sometimes intermittent, sometimes perennial, but often for significant lengths. You might be putting them in culverts or filling them in or otherwise impacting them. If you are that developer, you are going to care a great deal about whether your projects are authorized under individual or general permits. If you get a general permit, you know in advance what the terms are going to be. You might not even have to provide notification to the Army Corps. But by contrast, so it's going to be fast and predictable. By contrast, if you get an individual permit, the Army Corps is going to analyze alternatives to your project under the Clean Water Act. The discretionary decision is also going to trigger the National Environmental Policy Act. The state is going to be looking over the Army Corps' shoulder using a provision known as Clean Water Act Section 401. And if there are endangered species present, you've got to worry about that too. So much more time, much more money, much more uncertain outcomes, perhaps an order of magnitude of difference in costs. So that means you're also going to care a great deal about where the thresholds are between eligibility for general permits and where you just have to go for an individual permit. And those thresholds have changed quite a lot in the last 20 years. So 1991, if you were that developer, your threshold for having to get an individual permit would be 10 acres of impacts to streams. And you wouldn't even have to provide notification unless you were impacting over 1 acre of streams. If you think about it, streams, headwater streams, they're not big. Headwater stream might be about that wide. And if your stream averages, say, 8 feet wide, you can impact well over a mile of that stream before you even reach that 1 acre threshold. So it really was just a fill-at-will regulatory regime. In 1996, partly in response to litigation from the Natural Resources Defense Council, the thresholds dropped. But those are still pretty generous. That's still potentially a lot of stream impact. 2000, they dropped again, and nationwide permit 26, which is sort of the villain of this story, was phased out. In 2002, a slight step back. Now waiver requirements or waiver options were added, and these limits could be waived by the Army Corps District Chief. But in 2007, in the later days of the George W. Bush administration, a big drop again in the thresholds because now ephemeral streams were included in the calculation. And in 2012, the limits remained intact. So this may sound kind of arcane and picky. Permit terms aren't the most exciting things to go hear a lunchtime talk about. But permits are how environmental law gets implemented for the most part. And here, from the perspective of a developer, this is a huge difference, or somebody who cares about protecting streams. In 1991, you could pretty much do whatever you wanted. Now, in 2012, you're going to think carefully about impacting streams at all. There also have been significant changes in the types of regulatory requirements that we impose. And one of the most interesting changes involves the emergence of compensatory mitigation requirements for streams. So remember a little while ago I showed you the slide about how, streams that were lost were just lost. They weren't protected, they were just written off and no compensation was required. In the last really about, again, 15 years, that has also changed dramatically. And the change started kind of humbly. It started here. This is Haynes Mall Boulevard in Winston-Salem, North Carolina. And in the mid-1990s, this development got proposed, and it was going to involve putting a significant length of stream in a culvert. And North Carolina state regulators weren't pleased about this, or more generally what was happening to streams as their state went through a development boom, but they didn't know what to do about it. They didn't have the political leverage to simply stop these projects. They knew they couldn't just deny permits, so they wanted to do something else, and what they turned to was compensatory mitigation. Using authority under Section 401 of the Clean Water Act, which allows, well, sort of oversimplified, it basically allows states to impose conditions on federal permits. They required the Army Corps to in turn require compensatory mitigation for any project that was going to impact streams. And from that origin, this requirement of compensatory mitigation became more frequent and more prevalent. So these bars show you the extent of compensatory mitigation credits being sold by mitigation banks, which are private entrepreneurial ventures that restore aquatic resources and then sell credits to people who want to destroy equivalent aquatic resources. And you can see here that compensatory mitigation was already taking off for wetlands in the early 1990s, in the late 1990s. Nothing happening for streams until 2000, but since then, the prevalence of the practice has grown significantly. And this past summer, I went onto the Army Corps' mitigation banking database and took a look at where stream credits were actually being sold, just to see where the practice is occurring. It's still heavily concentrated in the southeast. That's where the roots are. But it is becoming increasingly nationwide, with credits available in a lot of other parts of the country as well, although not yet here. It's also becoming, in some ways, a more sophisticated practice. And the best indicator of that is the emergence of guidance documents, which sound about as exciting as permits, but again, they matter quite a bit for stream mitigation. And to explain why they matter, imagine for a moment that you are a regulator who is overseeing wetland and stream impacts, and your state DOT comes to you and says, we want to build a bridge across this stream, and we're going to impact it. Well, in order to figure out how much compensatory mitigation they need to provide, you need to figure out what the ecological value of this stream is and how much it's going to be impacted, and then you need to put some sort of value on the restoration project, and in order to do that, you're going to have to think about a lot of different things: biodiversity, sediment, other measures of water quality, the form of the stream. It's a fairly complicated process, and if the metrics aren't done very well, then the people doing the trades are just going to game the accounting and the environment is going to lose. So having some sort of guidance document that provides predictable and consistent measures for governing this sort of trade is really almost indispensable for doing it well. In the 1990s, regulators had no clue how to do this. The science wasn't there. And they were aware that problems were happening with streams, but they just didn't know how to go about governing compensatory mitigation. And even as late as 2000, the only stream mitigation guidance document out there in the country was one from eastern Kentucky. And it was designed to deal with coal field impacts, and it wasn't all that good. Over the coming years, these types of documents have spread and spread until now almost the whole country is covered, and a lot of the areas that don't show up as covered on this map are working on them. So again, I think this is an indicator both of how much compensatory mitigation has spread for streams and also how, over time, the practice has become a little bit more rigorous and a little more carefully governed. Finally, there have been some changes from the top. A lot of the stuff I've been talking about really bubbled up from Army Corps districts and from the states. But there have been changes at the top. So first off, in 2002, Army Corps headquarters issued something known as a regulatory guidance letter that stated that compensatory mitigation requirements and the no net loss policy applied to streams, not just wetlands. And then in 2000, so there's the key language. In 2008, again in the waning days of the W. Bush administration, EPA and the Army Corps came out with new rules governing compensatory mitigation. And the rules, and particularly the preamble, make very clear their expectation that compensatory mitigation would be required for streams. Now, all of the regulators that I talked to agreed that this was a really big deal, that this shift that had occurred had a lot of impacts, both in terms of positive impacts for environmental protection, but it was also going to affect regulated industries. And so I went looking to see what John Boehner had to say about this rule, or about the 2002 regulatory guidance letter, or about any of these other changes, or what any other conservative politician had to say, or liberal politician. And it turns out nothing. All of this was just flying under the radar, with the exception of Appalachian coal country, where this stuff has been litigated and litigated and litigated. Everywhere else, it wasn't generating cases, it wasn't generating politician statements, it wasn't generating any coverage in the news media. The only people complaining about this new rule were a few environmentalists who I don't think even understood what the rule was actually doing. So all of this leads to a question: is this actually working? Are these new requirements, these permit requirements, and is the compensatory mitigation actually accomplishing something? And the answers there turn out to be a little bit mixed so far. These are a couple recent assessments. The top one is focused on coal country streams, where we might expect things to be done particularly badly, but the bottom one is a more general study. And these assessments fit, I think, with a broader critique you often hear of compensatory mitigation, which is essentially that it's not real compensation, it's sort of a sham that's just greasing the skids toward development. And it might think that all of these changes aren't really as positive as I might have made them sound. With that said, I think there's a couple things to keep in mind here. One is that even though a lot of the literature on compensatory mitigation makes it sound like it's a choice between stopping projects or letting them go forward with mitigation, really quite often it's a choice between letting projects go forward without mitigation and letting them go forward with it. That's the political reality in which agencies operate. And even if mitigation is not done all that well, it is likely to be better than nothing. Second, there's this attitude, this was the attitude of the North Carolina folks who really got this going. They knew that the science wasn't out there to support what they were doing, that it was going to be done badly at first. And we tend to think that, well, the science should come before the law. That is how we tend to think of environmental law evolving. But they weren't willing to wait. They basically said, look, if we create the policy need, scientists will do the research, and eventually they'll figure out how this can be done well. And I think that is exactly what is happening. In all my interviews with folks at the Army Corps and at EPA, nobody ever said, we've got this all figured out and we're doing it well. Instead, what I heard was, we're doing it better and we're committed to learning a lot more. So where does that leave us? Well, I think progress. If the new jurisdictional rule is replaced by something far more limited, everything the Army Corps and EPA have accomplished gets thrown out the window. And more generally, good effective story mitigation, it requires real governance. And if that governance goes away, and it's very much under at Northeast and a lot of the places where the biggest changes have been occurring, then none of this is going to be done very well, even if our understanding of how to do it gets more sophisticated. More broadly, Section 404 is just one of many laws to those streams. And if we want to really protect streams, we've got to think about pollution flows into them, and we've got to think about land use changes around them. But with all that said, I think this still is a major development in environmental law, one of the most important developments in the field of water quality law in recent years, and it's one that's flown under the radar. So what does that mean? Why does it matter? And again, I think one answer is that an important and pervasive and often overlooked resource is getting protected more than it once was. But I also think there's an important lesson here and an important counterpoint or set of counterpoints to some of the darker contemporary narratives of environmental law. These stories we often hear about how we are stuck, we don't make progress, everything is trench warfare, everything is politicized. And if you dig down into those narratives, there are a couple of recurring themes within them that I think this story partially, and partially is an important point here, but partially rebuts. So one of those stories, or one of the recurring themes, is a deep cynicism about the role of government agencies. So to hear John Boehner and his friends tell it, agencies are simply hell-bent on controlling people. These are simply captured and will only act to protect the environment if they are successfully sued. And then within academic circles, we often turn to theories like public choice theory to try to explain agency behavior. And a very sort of oversimplified Cliff Notes version of public choice theory is that it posits that agencies are sort of passive or at least sort of strategic entities that simply respond to the balance of power created by external interest groups. The idea of an agency sort of idealistically identifying a policy problem, thinking carefully about how to respond it, and itself being a creative engine of reform does not figure very prominently in our political and legal narratives. And yet I think that's a key part of what was happening here. There was litigation, but not that much, and very little outside of the coal fields. I found very few cases in this realm. And there was political involvement, but again, not that much. And it's striking how many reforms occurred when George W. Bush was in office. And I think the best explanation for it, and an explanation that is entirely consistent with what I heard when I talked to people at the agencies, was that the Corps and EPA, as well as state and the Fish and Wildlife Service and some of their partners, were actively driving these changes. I often heard statements from Corps staff who said, well, it just seemed to me like the logical next step for the program was to start protecting streams the same way that we were protecting wetlands. And I think that should give us some basis for optimism in other fronts where agencies really are taking the lead on developing environmental law in an era when statutes really aren't doing very much to change. Is the trench warfare theme. The idea that everything is a zero-sum game, that when environmentalists win, industry lose, and vice versa, and that therefore we just duke it out and nothing really changes very much at all. And so here, first off, things have changed. There is a dramatically different regulatory regime from what existed in 1997. But the changes have not been entirely zero-sum. So there are clear gains for environmental protection, and I think there are more gains to be realized. But at the same time that the scope of protections has been expanding, the Army Corps has been developing protective mechanisms that are designed to be sort of efficient. Things like general permits getting more advanced, that are designed to be more efficient for regulated entities. And the environmental consulting industry has continued to grow, the mitigation banking industry has continued to grow. And so now there are whole industries out there that are designed to find ways to make a heightened level of protection work, to make it functional for industry. And I think, again, this in some ways is a microcosm of what happens in a lot of areas of environmental law, with this sort of game of mutual accommodation taking place often in the shadows of the more prominent litigation game or political battle game, but ultimately leading to a system of environmental law that is more protective than what we used to have and that still works for the industries that are regulated. And so where that leaves us, and where I'll close, is with the possibility of a different telling of the history of environmental law. So the conventional telling is that we had this incredible outpouring of statutes in the 1970s, that was a period of glorious leadership for United States environmental law. And then we lost it. We lost the lead. We lost our ability to do new and amazing things. And this telling is somewhat different. It would be that there was this amazing outpouring of legislation in the 1970s. And those statutes were really thoughtful and far-reaching. A lot of little actions. And we were naive in not realizing that we didn't quite have the tools to make that happen. And so over the last 40 years, what we gradually have been doing with little streams and on many other fronts is actually finding the mechanisms that can make environmental law work. And often doing so not just through litigation and confrontation, and negotiations between industry and environmental groups and the regulators. And I think it's important. So obviously that story is not entirely new. You can find a lot of that story in the writings of many people in this room. But I think it's one we don't emphasize quite enough. And it's important to continue to emphasize. Era, who would much rather see states battle against the Clean Power Plan than work with it and see if they can find a way to make it work. And the other thing is I think it may impoverish the way we teach and the way that students perceive future environmental careers. I think we tend to teach environmental law in a manner that is somewhat analogous to the way US history used to be taught. It was a series of wars and battles. And of course those wars and battles were real. They happened. They had very real consequences and they were important. But there is so much that goes on that is not the war or the battle. And I think it's important for us to remember and to present to students the possibility that your contribution to environmental law might be to draft a really creative and effective permit for your clients that helps them comply with a statutory requirement while also meeting the goals of the regulators. That it might be doing something other. So ultimately, I think that is why the story, it's an imperfect story, it's an ongoing story, but yet can still achieve and has still achieved in recent years. And it shows us also, I think, some of the things we can still do. So thank you very much, and I look forward to your questions. And I should say, for purposes of the recording, I may repeat a summarized version of the question just because the mic can't hear you. So yes?
I really enjoyed the presentation very much. I'm wondering how you got into this and if you read Cadillac Desert somewhere along the way.
I think I've only read it twice. But so yes, so into this particular topic, so the answer on this particular topic is that I was researching an article on what regional offices within the federal government do and why they matter to ideas about federalism and administrative law. And that was what led to all the interviews, or most of them. And I kept hearing about streams. People kept talking, and I realized at some point, when I asked people about innovations or changes that their district had been a part of, streams kept coming up. So I started to think, I've never heard this story. I thought, this is cool. And this does not fit the way a lot of people talk about environmental law. So that is what brought me into the subject.
Professor Owens, I
Mm-hmm.
One of the things you really haven't addressed, and I thought this was a very thoughtful presentation, a wonderful subject. But one of the things you really haven't addressed is enforcement and the importance of enforcement. Because from my perspective, nothing worked without that.
Right.
I'm just wondering, you talked to a lot of people at EPA and the Corps of Engineers. Do you have a program on this these days? Because that worries me.
So I think I never asked that question just straight up, how are you guys doing on enforcement? Because the focus of the research was in somewhat different directions. But I did get some interesting answers to other questions that shed some light on that question. One guy in particular talked about how in his district he had started setting up lots and lots of field offices. And the reason he set up field offices, one of the reasons was so his employees didn't have to drive as far to get to their sites. But another reason was that he realized the program had no visibility, that they would set up a field office, maybe bring an enforcement action or two, and then all of a sudden they would have all these additional requests for permits. And so he looked at this and basically thought, oh my goodness, we've just been implementing this program in the geographic areas close to our offices. And people elsewhere, it's not that they were sort of flaunting it, they didn't even know the regulatory program existed. And it wasn't until they set up shop in that area that enforcement or that any sort of compliance began to occur. That leads me to think that this was a district that had done more to set up field offices than any other. That leads me to think that there probably are still a lot of places where enforcement resources are very spotty, and then other people who've done studies on this to a greater extent obviously have found that EPA's enforcement resources are stretched very thin. The Army Corps' resources are stretched very thin. I mean, consultant. And I think in a lot of industries there is a fear of enforcement that is out of all proportion to the actual realistic threat, which is, I think, a very healthy state of affairs. Because I think sometimes a little enforcement can go a very long.
What is an example, in your opinion, of like a successful compensatory mitigation project?
Some of the best ones. So there have been a couple projects in North Carolina, and actually a couple in Maine where I used to teach as well, where they have done what they refer to as out-of-kind mitigation, where they're not mitigating exactly the same type of impact, but where they've compensated for impacts to wetlands, sometimes low-value wetlands, by taking out dams. And the lift, the improvement in conditions for that stream or that river from doing something like that can just be dramatic. So that, I think, is a particularly good example. So I had a quote up there from the Martin Doyle paper that gives a generally dismal assessment of compensatory mitigation practices. The second, 8 pages paper have been done well. And going that basically, instead of trying to recreate, or at least his success levels tend to be fairly high. And that one of the problems is that we've had a bulldozer fixation so far.
Removal of low-head dams and things like that is gaining momentum in Headwater areas. I know it's pockets.
Yes, but not nearly enough.
Yeah, there's really no funding mechanism for it. It seems like unless there's watershed groups or mitigation that's necessary.
Right, and I mean, one thing I will say is that, and this actually grows out of the previous big project I did before all this Army Corps stuff was looking at dam removals and how to create incentives for them. One thing I learned through that project and through this one is there's a lot of interest at the Army Corps in some districts in trying to figure out how to use compensatory mitigation for wetlands and for stream impacts to drive dam removals. And it's something the Nature Conservancy is very excited about as well. But, right, unless you can really raise the money right now, there's not in many circumstances, there aren't good incentives for driving that. Yes?
I enjoyed your talk, but one of the things that I didn't hear much about, and that was the symbiotic relationship between House Public Works and the Army Corps of Engineers. And the Army Corps of Engineers has almost no Army in it. And when the '72 Act came about, it started to beef up with some civilians, and those civilians became the real example of how individuals could really make a difference. Because Bill Hedeman was one of the major drafters of the '72 Act. Lance Wood headed that program for many, many years. And it was those people, the civilian environmentalists within the Corps, that really helped shape the 404 program.
Yeah, no question. And unfortunately, I can't just post all the transcripts from the interviews that I did for confidentiality reasons. If I could, it's a fascinating oral history of the Corps. Because a lot of the people I talked to, there were a number who had been at the Corps since the early 1970s. And they did talk about exactly that one district chief who, it was part of it, like, you know, the whole quote was, I would have put the whole paragraph up if I could. He talked about how, you know, he got there and their personnel manager told him, oh yeah, you biologists, you're a dime a dozen. He couldn't get a promotion for several years. I mean, he just felt like a pariah in his own agency. And then later on, he's the district chief. So, yeah.
I imagine talking to a lot of the employees of these, they talk about your process, how you got access to them.
Yeah.
Go see them.
So I had done research projects like this before, although I don't think I'd ever done quite this many interviews, but I'd done research projects before where a component of it was calling up staff at EPA or at the Fish and Wildlife Service or the National Marine Fisheries Service and doing an interview. And for those of you who are students who are thinking about a research project, that is a really fun way to do research, to have an actual talking to people about what they do component of your research. And that was easy with those agencies. With EPA, just called the people I wanted to call. I didn't say anything about giving them anonymity. They were perfectly happy to have their names on the record. And so I thought, okay, I want to do the Army Corps. EPA is too big. I want to tackle the Army Corps for this project. So I called up a contact at the New England district office, who was somebody I was sure would be happy to talk. And she said, oh, sure, I'd be happy to. Let me just run it by counsel. And a week later, she came, sorry. Counsel says, absolutely not. You cannot talk to this man. And I said, well, let me give you a little more information about what I'm doing. I'm going to make you guys look, I mean, I can't promise it's going to be unbiased, but I'm probably going to reveal some things about what you do that might be helpful. Some transparency might be good. She said, okay, I ran it by counsel again. I tried. Still, absolutely no. So then I talked to DOJ. And I contacted Andy Mergen, who's the head of the Environmental and Natural Resources Division at DOJ. And I said, can you help me with this? And he said, are you sure you want to talk to the Corps? He's like, why don't you talk to the Forest Service? It would be so much easier. I said, no, I want to talk. All right, fine. So he got on the phone and he talked to a couple people at Corps headquarters. And then they put me in touch with somebody else at the Corps who clearly had tons of credibility within the agency and decided, okay, we'll work with this guy. And it was kind of interesting because not much at the Corps is done by headquarters. There's not much, but there's only 10 people at their headquarters office. It's not a very influential office by federal agency standards. But on this one, once I had an email from headquarters going out to all the district chiefs saying, this guy wants to talk to you, can you talk to him or put him in touch with, but I still, I gave anonymity to every source. Some of them, the retired folks could care less. They were just like, oh, you can use my name if you want. But just to be consistent, I gave anonymity to all of them. And then the fun thing about it is once you get people from federal experiences, they will be very blunt. They will tell you things that are frustrating to them, And they're often usually eager to talk about that because they're mid-level agency employees. Nobody goes and asks them. They just get yelled at by Congress. So somebody to come along and be interested in what they do is kind of an exciting opportunity for them. So that's the process. I'm keeping you past time, aren't I? Or are we out?
Remind you of upcoming programs, including on the 22nd, India's Environmental Challenges. On the 17th, the Mountain Accord program here. And recent developments in Utah Stream Access Law on December 3rd. So thanks again for joining us. We'll see you soon.
Good to see you.